Today we're talking about what happens in a criminal trial during the defense's case. If you're involved in a criminal case in court and you've chosen to challenge or to contest the charges against you in a trial, the second stage of the trial will involve the start of the defense's case and the examination of the defense witnesses. The main purpose for this is for the defense, you, to produce and present the evidence that you feel supports and proves that you have not committed the offence and disproves the allegations made against you. What happens when it is your turn to give evidence? The first stage is the examination in chief. Assuming that you've chosen to give evidence, you'll be the first person in your defense case to give evidence as part of your defense. You can ask the judge for some time before you actually begin your case to think about what you want to say in your defense. You can then begin by giving a summary of the reasons of why you're not guilty and to give your own version of what actually happened and how it explains why you are not responsible for the offense taking place. This is called the examination in chief of the accused person, which is you, and it's an opportunity for you to present your own version of the events in relation to the offense and the allegations made against you. The second stage is the cross-examination. This is where the prosecution will ask you questions to cross-examine you. The prosecution can also produce the written interview statements recorded from you by the investigators during the investigations. If you feel that these statements should not be presented as evidence for the trial, for example, if you feel that they are inaccurate because you only made them after you were forced, or you were threatened, or you were bullied into making them, a separate hearing will be conducted for the judge to hear your reasons and arguments why these statements should not be presented and included as evidence at the trial. In any case, you should remember that even if the statements are presented and included as evidence by the prosecution against your wishes, you can still argue that the judge should only give very little weight to them. For example, by showing that the contents of the statement are not very accurate or reliable. The third stage is re-examination, and after the cross-examination, you'll be allowed to clarify what you said in response to the prosecutor during cross-examination. What happens when it is your defense witness's turn to give evidence? When you've finished giving your own evidence, you can then call your other defense witnesses to the stand one by one. The first stage is the examination in chief again, and this is where you ask your witnesses questions which you feel can help and support your defense and your explanations or weaken the prosecution's case. However, you should only ask questions that the witness is actually able to answer, and the witnesses should only testify to relevant facts within their personal knowledge. The questions you ask your own witnesses should also be open-ended questions, meaning that the questions asked must not suggest or give the actual answer or lead them to the answer that you want. You should remember that you cannot ask your witness his views of the events of the evidence of other witnesses, his opinions unless he is called to testify as an expert witness, his comments on the law, what his intentions and thoughts and views of another person are. Your defense witness should only give evidence of relevant facts that are within his personal knowledge. And the second stage is cross-examination, and once you're done asking your witnesses questions, the prosecution will then have the turn to cross-examine your defense witnesses. The prosecution can ask leading questions to challenge their evidence during cross-examination. And the third stage is re-examination. After your witnesses have been cross-examined by the prosecution, you'll be able to re-examine your witnesses, this time to clarify what your witnesses had said earlier during cross-examination. You can ask them questions to explain or to contradict matters put to him by the prosecution, which he might not have been able to clearly clarify during the cross-examination itself. You should remember the following during re-examination: that re-examination is not another opportunity to bring up or to raise new evidence. Re-examination must only be used to explain or to clarify matters that have been referred to earlier in cross-examination, and that you should only ask open-ended questions instead of putting your version and asking the witness to agree or disagree or say yes or no. So there you have it, some very basic information about what happens in a criminal trial during the defense case. Thanks for watching.